Is a will the right choice or a trust? One wrong decision can drag family property all the way to court. Imagine everything is peaceful in a home. An old family photograph hangs on the wall of the drawing room, property papers are kept in the cupboard, there is some jewelry in the bank locker, and looking at his children, a father always thinks that their future must remain secure after him. But one day, that very father suddenly leaves the world. There is mourning in the house, but within a few days another fear emerges. Which property belongs to whom? Who will handle the bank account? Will the house be sold or kept? And the biggest question, did the father make a will, or did he create a trust? The fear begins right here, because the very assets a person spends their entire life accumulating often break the family apart after they are gone. And the curiosity is, what exactly is the difference between a will and a trust, and what should a common man choose between the two? We often think of estate planning as something for wealthy people. We feel that those who have crores worth of property, large businesses, and a lot of land need a will or trust. But the reality is different. If you have a house, a little bank balance, some gold, an insurance policy, mutual funds, or a family business, then who will get all of this after you are gone is a question that should be decided during your lifetime. Because if a person does not make this decision himself, then later, the law, paperwork, family disputes, and the court decide it together. A will is a legal document in which a person writes down during their lifetime who will receive their assets after their death. In this, houses, land, bank balance, shares, gold, business shares, and even personal belongings can be mentioned. The most important thing about a will is that it comes into effect only after the person's death. As long as the person is alive, they remain the owner of their property. They can sell it, gift it, and change the will if the need arises. The strength of a will lies in its simplicity. A person can write clearly that after me, my house should go to my wife, my savings should be divided equally among my children, a separate amount should be kept for my daughter's education, and some money should be set aside for my mother's care. It sounds simple, but this clarity can save a family from a major fight later on. Because where there is no written wish, there is guesswork, and where there is guesswork, disputes often arise. But making a will is not just about writing a wish on a piece of paper. Under Indian law, a will must be properly executed. In a normal situation, the person making the will should draft the document while in their right mind, without any pressure, and of their own free will. It must have their signature or thumb impression, and the attestation of 2 witnesses is very necessary. Many people make the mistake of writing a will, but not including witnesses in the proper manner. Later, this small mistake can put the entire will into dispute. Getting a will registered is generally not considered mandatory, but many experts view it as a form of practical safety. A registered will has a record in the government office, so accusations of it being lost, changed, or tampered with can be weaker. Still, registration alone does not make a will perfect. If the will is drafted incorrectly, if there are questions about the person's mental capacity, or if someone in the family feels the will was made under pressure, a dispute can still arise. Now let's talk about a trust. Hearing trust makes it feel like it is some big corporate or charity structure, but a family trust can also be an important tool for estate planning. In a trust, the owner of the property keeps their assets in a legal arrangement. They entrust a trustee with the responsibility of managing this property for the benefit of the beneficiaries. Beneficiaries are the people for whom the trust was created, such as children, a spouse, parents, or any dependent family member. The greatest feature of a trust is that it can start working during the person's lifetime. In a will, control comes after death, but in a trust, the structure can start at the living stage. For example, a father wants his property not to be sold yet, his wife to be cared for with the income, his children's education to be completed, and for them to receive a larger share only when they reach a certain age. In such a situation, a trust can be more useful, because it defines not just the property transfer but also the way it should be used. In a will, you can write who will get the property, but after receiving it, your control over what that person does with it becomes very limited. Suppose a child suddenly receives a large property, but they are immature, lack financial discipline, or could come under the influence of the wrong people. In a will, the property will transfer, but after that, preventing misuse can be difficult. A trust works like a guardrail here. The trustee manages the assets and provides benefits to the beneficiary according to their needs, age, education, or specified conditions. Family situations today are no longer as simple as they used to be. Somewhere there is a second marriage, somewhere children are settled in different countries, somewhere there is a family business, somewhere there is a special needs child, and somewhere elderly parents are dependent. In such situations, the formula of just divide equally among all children is not practical. Sometimes dividing equally also becomes injustice, because one child might need cash, one might need the right to live in the house, and a dependent member might need lifetime support. A trust can handle such complex family needs in a more flexible way. But this does not mean at all that a trust is always better than a will. Creating a trust can be a more structured and costly process. A trust deed must be drafted carefully. If immovable property is being transferred into a trust, the issue of registration and stamp duty may arise, which depends on state rules and property type. The selection of a trustee is also very important because the responsibility lies in the hands of the trustee. If the trustee is not honest, capable, and neutral, then the trust can also become a new cause for family disputes. The cost of a will is generally lower, the process is simple, and for an average family it can be a quite practical solution. If assets are simple, there is trust in the family, beneficiaries are adults, and there are no special conditions, then a properly drafted will can work very well. For example, a person has one house, some fixed deposits and mutual funds, and wants a clear distribution among their wife and 2 adult children. In such a situation, a will can be a simple and effective path. But if the property is very large, there are assets in different cities, there is business ownership, there are minor children, there is a possibility of conflict in the family, or the person wants the property to be transferred slowly and with conditions, then a trust can provide better planning. A trust is not just a way of giving away property, it is a system for managing the property. This difference is very big. A will is a direction, a trust is a mechanism. Earlier there was a lot of confusion regarding probate in cases of wills. Probate means legal confirmation of the will's authenticity from the court. Earlier, probate requirements were considered more important in matters related to some communities and specific cities, such as Mumbai, Chennai and Kolkata. But in 2025, Section 213 of the Indian Succession Act was omitted, which changed the old situation regarding mandatory probate. This does not mean that the concept of probate has ended. It means that now, viewing probate in every relevant situation as a statutory precondition is not the same as before. Still, if there is a dispute in the family, a high-value estate, or if banks and authorities want extra assurance, then voluntary probate can be practically useful. Regarding tax, there is also a big fear in people's minds. Many people think that if property is received through a will, heavy inheritance tax will be applied. Currently, there is no inheritance tax or estate duty applicable in India. In the income tax framework, property received through a will or inheritance generally gets an exemption from gift tax type taxation. But this does not mean that every future transaction will be tax-free. If the beneficiary later sells that property, earns rent, earns interest, or if there is a capital gain, then normal tax rules may apply to that income. Therefore, in estate planning, one should not just look at who will get the property, one should also see how the future tax impact will be managed. Trust taxation is an even more sensitive area. The type of trust, whether beneficiaries are clearly defined or the trustee has been given discretion, where the assets came from, how the income will be distributed, all of these can affect tax treatment. If the beneficiaries in a family trust are relatives, some transfers can be simple, but wrong drafting can create double taxation, disputes or compliance burdens. Therefore, downloading just a template deed while creating a trust can be dangerous. Combined advice from a lawyer, tax advisor and financial planner can be very necessary here. Now understand this with a story. There is a businessman who built a factory, 2 houses, some investments and a brand in 30 years. He has 2 children. The son is in the business, the daughter is a doctor and is not interested in the business. The wife is financially dependent. If he makes just a simple will and distributes the assets half and half, the management of the factory can get tangled. The daughter might need cash, the son might need business continuity, and the wife might need regular income. In such a situation, a trust or a detailed estate plan could be better, where business control, income support and fair compensation can be decided in different ways. Now look at another story. There is a retired government employee who has 1 house, a pension, some bank balance and 2 adult children who have a good relationship with each other. He just has to decide that after him the house should remain in his wife's name and after his wife it should go equally to the children. In this case, a clear will could be more practical. Creating a trust here might create unnecessary complexity. This means the solution depends on the person's property, family structure, and intention. The biggest mistake is that people get scared by associating estate planning with death. In reality, a will or trust is not a preparation for death, but a preparation for family protection. Just as insurance is not taken to invite illness, A will is not made to invite disputes. It is made to prevent disputes. As long as everything is fine, planning is easy. But when death, illness or incapacity arises, the family is emotional, and paperwork also starts feeling heavy. Another mistake is that people consider nomination as ownership. Being a nominee in a bank account, insurance, mutual fund or flat does not always mean being the final owner. In many situations, the nominee can be the person receiving the asset, but the claim of legal heirs can become a separate question. Therefore, nomination is necessary, but it does not take the place of a will or estate plan. If the nomination and the will are saying different things, confusion can increase. It is better that nominations, the will and actual intentions are all aligned. While making a will, the language should be simple and clear. Very complicated words sometimes increase confusion. Who will get which property? Who will be the executor? If any beneficiary dies earlier, then to whom will their share go? Who will be the guardian for a minor child? And how will debts or liabilities be cleared? These things should be written clearly. A will should also be updated from time to time, especially after major changes like marriage, divorce, childbirth, property sale, new investment or family dispute. While creating a trust, the choice of trustee is the most critical. The trustee can be a family member, a professional, or a combination of both. But the trustee should not just be trustworthy but also capable. They should understand accounts, understand compliance, know how to balance between beneficiaries, and should not misuse trust property for personal benefit. It is also not right to create a trust and forget about it. Its accounting, tax filing, asset management, and beneficiary communication should be done properly. If anyone has the question of whether to make a will or a trust, there is a simple answer for this. If your assets are limited and straightforward, beneficiaries are mature, and you only want distribution after death, then a will can be enough. But if you want lifetime control, asset protection, security for minor or dependent beneficiaries, business continuity, privacy or stage distribution, then a trust can be considered. Many families also use a combination of both. Some assets are kept in a trust, and for the rest a will is made. In the end, the matter returns to that same house where the family was searching for property papers after the father's passing. If there had been a clear will in that cupboard or a well-structured trust, then perhaps there would still be grief, but there would be no confusion. Perhaps the family would not have had to make rounds of the court. Perhaps the children would not have had to guess what the father truly wanted. And perhaps the assets, instead of breaking relationships, would have become a support to sustain them. There is no fight between a will and a trust. Both are tools, and the right tool is the one that fits according to your family, assets and intention. The fear of wrong planning is not that the money will run short. The real fear is that your hard-earned money, after you are gone, becomes a question between your own people. Therefore, do not postpone estate planning. Because building assets all your life is intelligence, but ensuring that it goes into the right hands after that is foresight.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.